There we go. Great. Okay, good afternoon. My name is Haley Lyons, and I am the chair of the Board of Accountancy. I'm calling this special Zoom-only public meeting of the State of Oregon Board of Accountancy to order. Today is Monday, June 29th, 2026, and it is 12:01 p.m. This meeting is being held by Zoom, with most staff participating from the board offices on 200 Hawthorne Avenue, Southeast Suite D450, Salem, Oregon 97301. This meeting is being recorded. For all Zoom participants, please be sure to mute your microphone and unmute only when you are called upon to speak. Please do not use the chat room for any discussions. Should any technical issues arise, the meeting will be paused until they are resolved. I will now take a roll call of members and guests. I will start with who I can see on Zoom, followed by staff at the board office. Okay. Jason Orm.
Jason Orm, board member.
Raul.
Raul Valdivia, vice chair.
Awesome. Jason Robinson. He looks like he froze. Or did I freeze? No? Okay, Logan Steele.
Logan Steele, board member.
Tanya.
Tanya Moffett, board member.
Megan.
Megan Hartley, board member.
And we will go to board staff. Shelley.
Shelley Outstrom, Deputy Director, present via Zoom.
Awesome. Martin.
Martin Piccioni, Executive Director, present by Zoom and at the office.
Quinn.
Quinn Stoddard, present via Zoom or Docs.
And you're the only one, obviously, in your space.
Yes.
Okay. If you were in the conference room, and it's the way that the script indicates in case there's additional people. So that's why I'm asking. Okay, great. Joanna.
Joanna Tucker Davis. I'm an assistant attorney general, and I'll be helping you all out for the next 3 months.
Thank you. Welcome. Okay, and to our guests, Sherry.
Sherry McPherson, CEO, OSCPA.
Awesome. Amanda Fells.
Amanda Fells, OAIA Board Liaison.
Ray, who's now just taking a drink.
Interim chair of the LRC.
Awesome. Jared.
Jared Holm, Vice Chair, Oregon Society of CPAs.
Marcus.
Marcus Rayner, the Accountants Coalition.
Thank you. And Jason Robinson.
Jason Robinson, Board Treasurer.
Great. I think I got everybody. Quinn, do you agree? Everybody's happy. Okay, good. All right. Has everyone had a chance to review the agenda? And does anyone have any proposed amendments to the agenda?
Madam Chair, could I please ask for a board member to make a motion to add TAC feedback on Laws and Rules Committee recommended legislative concept language changes as a new item under item 3, new business topic A?
So moved, Tanya Moffett.
Jason Robinson, second.
Great. Any discussion? Let's take a vote. Jason Orm.
Jason Orm, aye.
Raul.
Raul Valdivia, aye.
Logan.
Logan Steele, aye.
Megan.
Megan Hartley, aye.
Tanya.
Tanya Moffett, aye.
Jason Robinson.
Jason Robinson, aye.
Great. Haley Lyons, aye. Add agenda is approved as amended. I guess I should have asked if anyone else had any other amendments that they would like to add. Seeing none. Okay. Great. Moving on to item 2, public comment. Are there any members of the public who wish to comment? Please use the Zoom raise hand feature. If I call on you for comment, you will be permitted to address the board for a maximum of 3 minutes, and staff will unmute you so you can speak. As chair, I reserve the right to end your comment early and have staff mute you if your comment does not pertain to the authority given to this board by the legislature to regulate the CPA profession and public accountancy firms in this state. Any public comment? The members of the public that are here will be invited to comment also during new business. Great. Okay, new business, updated APS PE legislative concept language changes. We have Ray here, thank you, from the LRC to talk about the recommendations from the LRC. And Martin, so either one of you, take it away.
So I'll just start very briefly and then turn it over to Ray. I simply want to remind procedurally the board that you saw a very thoughtful set of feedback from TAC that was in your board meeting materials on June 4. Your request at that time was to have the LRC go through and figure out where it would make sense for us to make additional changes based on that very thoughtful feedback. That meeting occurred on June 22, which is only 1 week ago. It seems like there's a lot of things that have happened since then, but that was exactly a week ago when the LRC worked through it at exemplary just focus and speed in a very intense 2 hours and came out with recommendations you have in the packet. I won't go into the substance of it. I'll leave that to Ray. But Ray and the LRC did a fabulous job. So with that, Ray, I will turn it over to you if you want to discuss anything related to the LRC recommended changes.
Thank you. And I want to thank the members of the LRC. We met a week ago today, had actually quite a thorough discussion of the TAC comments. I want to compliment the LRC members in 2 ways. First, everybody came prepared. I mean, there was a lot to dive into. The quality of the discussion I thought was good. The other thing that I would tell you is as we talked through things and we proposed amendments, every amendment that was passed out of the LRC was a unanimous vote in favor of the amendment. Let me start with the first item in the TAC comments that we looked at in terms of the language around providing the professional services to external clients. The discussion was modest there. I think everybody came around quickly that we needed to add the external clients, and that became part of the revision to 1A that you see in the revised rules. When we talked about administrative service agreement, we came up with a revised definition of administrative service agreement that you see in 2. There was modest discussion about just what should be included, and we wanted to make sure it was for sharing of employees' services. And then there was a discussion about an underlying infrastructure that we thought needed to be included into that. And that's the change that you see in 2. And again, the vote on that after discussion was a unanimous vote. The third item raised by TAC in terms of APS agreements typically involve much more than just shared employees. By the time we got there, we had already proposed changes to the definition of administrative services agreement. And so the discussion at this point was relatively short because we felt that the proposed definition that had already been agreed upon by the LRC and put forward in item 2 incorporated our comments and thoughts there. With respect to the comment about allowing as further defined by rule, the committee was unanimous in the fact that it felt that the board needed that flexibility, that we couldn't tie it down to a point that wouldn't want the ability to update by rule. I think the feeling was things move relatively quickly, and the board should have the ability that if we need to amend by rule down the road, we can do that. Again, that was a unanimous decision by the LRC. With respect to the definition of professional accountancy services, what we had previously discussed as a definition was out of the statute, and we felt maybe the right way to respond to that was just refer back to the statute rather than trying to redefine it here or restate the statute here. So in item 3 on the definition of professional accounting services, professional is defined as previously it exists in ORS 673-010, and we just pulled that in. We just made the reference so it's clear that that's already in statute. We were not reinventing the wheel. And I think that walks you through kind of rather quickly an LRC meeting that was a 2-hour meeting. So I'm sure I've probably dropped some nuances along the way that were discussed. But nevertheless, I would tell you that the LRC spent some significant time both in conversation, talking through proposed wording changes, and the wording changes that you see were the result of a unanimous vote of the LRC one by one as we went through. Having said that, let me open it up to Martin or Jason. You were there if you have any further comments, and then I'd be happy to entertain questions if there are any.
If I may, just 2 very quick comments. One is that the comment you made about us retaining the rule writing authority was also directly tied to the impression by the LRC that the LRC had gone very, very long way to try to address the overall concern by TAC, which was really about, can you narrow this? Can you kind of roll this in a little bit and kind of limit what you're potentially capturing here? And beyond that, we still needed a little bit of that rule writing authority. But in general, there was this feeling like we had come a really long way in addressing the pieces that came, the concerns that came from TAC initially. The second piece I would like to add to just raise comments is that we essentially did live written language with counsel right there to make sure that the policy response that the LRC wanted to get to in response to the TAC concerns would be reflected in language that also had the blessing of board counsel. So we felt pretty good about kind of tackling both elements, the policy element and the how do we write this so that it also statutorily is well-founded in terms of that language. So that's the only 2 brief comments that I would make kind of and leave it at that.
Thank you, Martin. I think you well expressed the kind of some of the quality of conversation we had.
If I may, on item 4, with that exception by rule requirement there. So we can clearly make exceptions to the registration requirement based on this by rule.
Yes.
Is the intention not to accept, though, inclusions by rule? Like, can we pull someone in by rule instead of just excluding somebody by rule? And is that desirable?
That's a really great question. And Joanne, I hate to kind of put you on the spot quite so early, but I think
Can we bring the language up on the screen? That might be helpful for us all to look at it together.
Let's
No,
see here.
let's see. I know technology.
Hang on. Shelley, can you help us with that a second? It should be one of the PDF attachments. Do you mind
Yeah,
sharing?
I'm working on it.
Thank you. And Joanna, while she's doing that, can I just frame my question to you really quick?
Yeah.
So I think what Logan is getting at is the reason why we write this around we have the ability to exclude registrations. Part of this is a policy reason, right? Which is essentially additional safeguarding against with respect to the concern that we don't capture something. If it does turn out that we captured something in statute, in theory, that it gives us the ability to fix things by rule, right? But Logan asked the opposite question of could we expand it? Could we include more?
Yeah.
And I think this is where it gets into this legal issue of can we get beyond the framework of the statute? And I think that's more of a legal question than a
Right. No,
policy
no, I
question.
understand the question is you're saying there's this broad statutory definition that you can narrow by rule, or is there a broad statutory definition that you can also add to by rule? That's how I understood the question, or both. And wait, oh, sorry, this just looks really tiny on my screen, and I've got I've got it up too.
Is that better?
Yeah. So I think both, because if we go up to 2, right, if we just scroll up a little bit to 2, administrative services agreement for the purpose of this section means any agreement between a business organization and a CPA firm that references the sharing of employees, services, facilities, or infrastructures between a business organization and a CPA firm for a fee, or as further defined by board and rule. So that's saying you've got a statutory definition, and it also sounds like, I mean, we don't know what the ultimate language is going to look like, right, in the LC, but that the intent is to also allow the board to define what an administrative services agreement and rule is. And then below 4 then allows you to do carve-outs. So it sounds like you've got both. You've got the ability to further define what an administrative services agreement is by rule, and then you also have the ability to take out people that maybe meet that definition, but you don't think they need to register. Sure.
Great, thank you.
So do we have other questions or concerns on the LRC recommended pieces from board members before we move on to the later stuff?
Doesn't look like it.
So, Madam Chair, I think the cleanest way to do this is to kind of like try to capture the progress that the LRC has made by means of a motion to kind of update that language and then work our way through what came from in reaction to that updated language from TAC on Friday that the board got this morning.
Okay.
Kind of work our way through that. But I think it would be good to get that baseline. Is the board on board, no pun intended, with the LRC recommended changes and get a motion around that? And happy to help craft that if that's necessary.
I move that as a working document, we accept what's been presented by the LRC for further discussion with the additional information we received this morning.
Great. Can you state your name?
Jason Orm. Thank you, Haley.
Thank you.
Megan Hartley, second.
Thank you. Any discussion? Okay, we will take a vote.
Just one quick note.
Yeah.
In regards to that, considering that the TAC second or TAC response. Is the reason that my question came up is that second response excludes language around that inclusion possibility.
Right.
And so I just want to make a note of that before we vote.
Great. Thank you. Okay. Jason Orm.
Yeah, I, Jason Orm.
Thank you. Jason Robinson.
Aye. Jason Robinson.
Megan.
Megan Hartley, aye.
Tanya.
Tanya Moffett, I.
Logan.
Logan Steele, aye.
Raul.
Raul Valdivia, aye.
Great. Haley Lyons, aye. Motion passes. Thank you. Okay, so now let's chat about the if we need an additional amendment for language that, comments that we received from TAC in your email today. Martin, do you want to kick us off?
Yeah. So essentially on Friday, we had a very dynamic week last week, and we had a NASBA conference where Marcus Reyna, who's present here as well as the TAC representative, was there, and we kind of used that opportunity of all that momentum that we got out of the LRC, and it felt like, hey, things are going well. We're responding to their concerns. Can you take another look at the language? Right. And Marcus was very generous and said, yeah, I'll do another go round, and essentially came back on Friday with these additional language suggestions where I'm actually hoping, Shelley, can you do another one of your little miracle worker things and put up what we sent out by email to the board this morning on the screen, because I do think it will be helpful to have it on the screen, because there were essentially two sets of amendments, as I recall from the top of my head, that were getting proposed by TAC in the second round. And now these are amendments relative to the language that we've tentatively accepted by means of our prior motion just now. And the first one that you see there is under the definition in 1B, proposing to add what you have in blue, the third-party equity. So the business organizations, one or more third-party equity or potentially third-party financial sponsor investors, and then deleting the or ownership interests held by non-licensed entities associated with a business organization. So that's the first one, and I will step back and stay out of a substantive discussion there, and maybe we'll start there. That's probably the potentially easier one of the two, not sure. But Ray, do you want to start off? I know you can't speak for the LRC, but do you have any?
Yeah, I'm speaking for myself as opposed to the LRC here, because this is not an issue that we discussed. But as I looked at this, and Marcus, I appreciate your comments. The one thing that strikes me that the LRC, quite honestly, didn't discuss and didn't incorporate is we talked about ownership interest. But I think something that has been overlooked to date would be third-party lending interests that, depending on the situation, could be of equal interest or of equal concern, depending on what influence they may have on the rest of the organization. So that was something that did come up in the peak exposure draft, did not find its way into our discussion. So when it says third-party financial sponsor, that may not necessarily be an equity sponsor, but I think something that I think is appropriate to incorporate.
Yeah, and I think for me, the biggest point here is the whole third party piece, just because I think right now there's different firm structures, even within the Big Four and others, where we could get into some sort of messy ground where it could get a little bit just unclear as to whether, you know, a non-licensed entity that might be a consulting entity is associated with an audit and assurance part of the practice. And so, and I don't think we're intending to pick any of that up with any of those that are just owned by common interests. Really, our interest is wanting to make sure that we're covering those with third-party equity and debt, I guess, to the point, to Ray's
We
point.
shall get into the definition of common control.
Exactly.
Yeah. Marcus, I think you had your hand up first, and then Jason Robinson.
Thanks, Haley. And first, let me just say thank you to Martin and this board for what I think is a very thoughtful and engaging process here. From our perspective, not only is Oregon an important state, but you guys are doing something important, pioneering here that may form the basis for a lot of law across this country on this. So we really appreciate your efforts to try to get it right. I think, Megan, you hit the nail on the head on what we're trying to do here, which is that, you know, non-licensed entities associated with the business organization could be construed to principal lawyers who are owners of the firm, high-level executives, others who are non-licensed. And Gibson Dunn, who we consulted on this, felt strongly that being very clear that it would be a third-party financial sponsor would make very clear what the board was intending to do here. And that's why we recommended that adjustment.
Thank you. Jason?
So help me understand the third party financial sponsor. Is that a bank? Could that be a bank?
Yeah, I have the same question, and I'm gonna, if I can expand on it just a little bit. The term third party is giving me pause, and probably because I don't fully understand all of the way that all of these different structures can work and what we're trying to pull in and what we're trying to exclude. I mean, I understand what we're trying to pull in and what we're trying to exclude, but how this language works with that. And to me, potentially we get into a conflict with the term third party because of common control. And what we're seeing, I don't know if a lot of the times is the right term, but what we are seeing is the assurance entity partners are still partners in the non-assurance firm. And so is it a third party? Like, could that? So I'm struggling with the third party financial sponsor. Is that a bank? And also, does the use of the term third party really include who we want to include, or does it actually exclude who we want it to exclude, is the way that I read it.
I guess in my mind, I hadn't gone all the way to financial sponsor thinking of that for debt. I do think that might require some further clarification because, yeah, if anybody has external debt from like Bank of America, you know, you wouldn't necessarily want to bring them into this. When I was thinking of third party equity, to me, that meant more clarifying that you're talking about a, you know, private equity investor or otherwise who is not affiliated with the current practice of the firm versus like, you know, an internal structure within a Big Four organization or other where there might be non-licensed consulting parties that are part of a, you know, that one could construe as being part of the attest and assurance side. But maybe you're trying to keep those clear, but those are all under common control. So I think in that case, we would not be saying that is a third party equity investor. And I don't think I mean, those structures have been around for quite some time. So the third party piece is really that private equity investor.
I see. Thank you.
I don't know, Marcus, if you had any other thought. I'm obviously not the one that came up with the suggested language, but.
No, I think that's right. I think my initial reaction was it depends on what the definition of business organization here is, right? And I think what you're trying to encapsulate at the beginning of this is that a business organization provides professional accounting services as a whole, along with other entities. And I think what this is trying to make clear is that it would be a third party outside of that larger organization.
Mm-hmm. Yeah. Ray?
Yeah, Megan, I understand your concern about On the debt side, there's borrowing in the normal course of business that I think we're clearly trying to exclude here. And at the same time, I'm recalling some specific discussions in the peak exposure draft that went beyond just equity investments. So I'm off the top of my head, I can't propose an answer. I clearly would want a definite. I'm more comfortable with the third party financial sponsor, but I think we'll have to do something to kind of clarify that in rule or. But I clearly want. I don't want it to be so sweeping that it includes a lot of things that happen in the normal course of business.
Yeah. Yeah, and that's fair. I think it depends on the definition of financial sponsor. I'm not exactly sure what that. We would definitely need to narrow that, I think. Yeah.
Yeah.
I agree with Megan. The financial sponsor, I'm not sure what that is. As I read, this is Jason Orm. As I read the language, could it be third party equity or financial sponsor investors?
Jason Robinson.
We're in this process here, we're talking about registering the non-CPA firm. That's the requirement. So the business organization is the non-CPA firm. And we're defining what that business organization as a non-CPA firm is that has one or more ownership interests held by non-licensed entities. Because if we have two CPA firms that are working in conjunction with each other, we don't care because they're both registered.
Right.
This is the guy that's coming in and doing the private equity thing and turning the CPA firm into a shell company. I don't know how the third party equity or third party I think it might be too succinct and include more than what we want, or not include what we're aiming for. Yeah.
Joanna, would you concur that from a strictly, setting the policy issue aside for a minute, from a strictly legal perspective, that the term third-party equity is a bit narrower than the third-party financial sponsor?
I honestly don't know enough to weigh in on what the difference between those two terms would be.
Okay.
Yeah. They're likely to be defined by the legislature as, well, a couple things. One is, I think there may be some room for the board to define those in rule, but I do think if there's legislative history on what those would mean as this process goes on, that would obviously be taken into account in how those terms are interpreted, whether the board provides that legislative history or someone else does.
I mean, if we wanted to, we could put third party equity or private credit. I mean, private debt means, an investor that is not a bank loan, traditional bank loan or corporate bonds or things like that. Private debt or private credit. Because that's financing provided by non-bank lenders.
So on a more third-party equity or private credit or private credit investors. Is that what I just heard?
Yeah, I mean, just a thought, if we're trying to encapsulate debt but keep out, traditional bank debt.
I like what Megan suggested. That's more clear to me. It's Jason Orm.
Yeah, I think so too.
So are we talking about, so I just want to kind of spell that out. So under item B, what I think I heard is that we're veering toward the business organization has one or more third-party equity or private credit investors, period.
Yes. Hey, Shelley, can you type that in there. So it would say just right after third party equity.
You want me to erase the tracking piece? Is that what you mean? Or just
No,
change this
I
right
want you
here?
to just
Got
type
it.
the words
Yeah.
so that we can see.
Yeah,
And
I
we're
can-
changing it to debt, third-party debt.
No, third-party equity or private credit. And then
Well,
delete
equity
everything
is
other than
there,
investors.
Maybe I'm looking at this too simplistically, but if we have somebody who is an active person in the organization and they're created this model to make money, they're not a third party equity investor, but they can still separate themselves from the CPA firm. They can still do the same thing. That ownership interest held by a non-licensed entity associated with the business organization clearly defines that it doesn't matter who you are when you're non-licensed and you're coming in with this agreement with a CPA firm, you're on the hook. This third-party equity alleviates that ownership piece. So I could not have a CPA license. I could own a business that I make a CPA firm into this different structure and not have to register now because I don't have any third-party equity. Am I looking at it wrong? Because it seems like we're clearly defining the worst PE structure we want to have happen and making them register. But we're missing out on potentially other private equity investors that have complete ownership and not by a third party of that company, but are still using the CPA firm just like. Am I making sense? Or am I just off my rocker today? I haven't had 2 cups of coffee yet, so.
Well, I've had 3 cups of coffee, and I agree with you. So that makes me feel better. Yeah, I've find this change to be disconcerting. I think you did a better job putting it into words, but it does seem to this third party part I find hard because it's third party to the other non-CPA firm, and that's not necessary. That other non-CPA firm in the agreement with the CPA firm could be owned by no third party. It could be just self-owned, and it's not a CPA firm. That's what we care about, and that's why the old language, non-licensed entities, makes a lot of sense to me.
So Jason and Logan, I think what I'm hearing from the 2 of you is that it may be beneficial to try to narrow this down by rule from the original language rather than limiting us more with the third-party language in the statute.
I think so, yeah.
Yep.
I would agree with that.
Yeah.
Tanya Moffett, for the record.
Jason Orm, I agree. I hadn't thought about the debt piece. As long as outside investor would also include a debt investor. And maybe we can do that by rule 2.
Logan here, with the debt side, that's a whole complex discussion because debt, if it's not convertible debt, if there's not restricted covenants, there's not really control. And so like, lumping debt in here is a complex issue, I think. And then we'll get in, if we just stick to equity, we'll get into issues where there's, equity debt kind of convertible stuff that makes things complicated. So that's a whole pickle to address.
I don't disagree, but a large debt holder also would have significant influence. So I agree totally with you, Logan. I do.
So I guess the only risk in leaving it as is that we scope in entities that we don't necessarily intend to.
But if we do, Megan, then my understanding is that with the language in item 4, we have explicit authority to scope out.
This is Raul. From somebody, can I have an example of an entity that might get swept into this that we don't intend to?
Well, in my mind, it's one where a firm has broken apart several of its components, call it consulting, tax, audit, maybe there's others, and there are ownership interests across those entities. They're all controlled by the same parent. But could you get into questions here where there could be some just some interest in potentially having those where they would need to explain how they are not part of this structure, I guess. And I guess I'm just making sure that what the piece that we're worried about is that I'm Joe, I'm not a CPA, and I go start a firm and I call myself a CPA. Or I'm just trying to think of like exactly what the piece is that we're thinking would not require a third party equity or debt, like third party coming in, because somebody who's not a CPA can't say that they are regardless.
But these are guys not saying that they're CPAs. They're just attached to the business and help structure and control the firm in that agreement, that administrative service agreement piece. So you're not talking about your CPA firm breaking off their consulting piece, and the CPAs still control the majority of that consulting process. We're talking about somebody who's come in and said, okay, so for all intents and purposes, we control your HR, your payroll, and we're providing all these administrative services for you, CPA firm. But we also control how much you get paid each year, what your jobs are going to be costing out at. And I think that the third party equity piece for that add-on function doesn't necessarily ring true to the non-licensed entity that's latching onto the CPA firm.
Yeah, and I guess just in my mind, in order for that to be lucrative for that party doing those administrative services, they have to have a stake in it one way or another. Right. I guess that's where I thought the third party equity piece would sort of come into play. They have some level of ownership somehow in the chain. But maybe I'm misunderstanding exactly how those investment structures are built. But
let me come back and ask the question. In our original language, where we talked about outside investors or ownership interests by non-licensed entities, who are we potentially sweeping in that we don't want to sweep in with the language that we had coming out of the LRC? And then with the following question, how do we if there are people that we're sweeping in that we don't want to, what's the right way to not bring them in if necessary?
Well, I don't know, Marcus, if TAC had specific thoughts about how they were thinking about that when they suggested the other language.
Sure. Sherry, I think, has her hand up, so I wanted to let her go first, but
Oh, okay.
Well, actually, I appreciate Marcus's comments because I was thinking about this where, it's already been through Gibson Dunn, and just from all this depth they have and looking at this, I'm kind of worried about the unintended consequences of changing that, and might some of what we've been talking about be what should go in the rule for more expansion. But I'll turn this over to Marcus because he's actually the expert and has been connected with the legal counsel.
Sherry, my understanding is unintended consequences because we trust the board as it's currently constituted, but working across 50 states, I can tell you sometimes boards get aggressive in their regulation in a way that has unintended consequences. And I think the concern here is outside investment by non-licensed entities could include existing advisory firms that are not current registrants with the board, as opposed to, I think, what you're trying to do, which is go after and capture folks that take private equity money or outside investors, truly outside the business organization, not with an affiliated entity that has administrative service agreements or shared revenue. And I think what Gibson Dunn is trying to do with the third party here is make it unequivocally clear that this is someone outside the structure of the business organization, which currently includes an insurance firm and potentially an advisory firm that is third party to the larger business organization. And I would be happy to, and I know time is short. Sorry, go ahead, Ray.
I appreciate your comments and understand, I think our conversation at the LRC was not trying to sweep in the organizations you're talking about.
And I think that's our understanding. And I know time is short here. I know Martin has a calendar here, but I'd be happy to provide more depth on this from Gibson Dunn if that would be helpful to the board. I know you probably want to make a decision today, but that's my understanding of the reason they have requested this, because the other language, yes, the board has the ability to exclude in rule going forward, but statutorily this could sweep in, I think, those advisory entities.
So, Haley, I think what I'm hearing here process-wise is I'm not sure that what I'm hearing here is a consensus on how to proceed. And so I think given that we're kind of torn between we historically want to work very closely, and I'm sure we want to continue to work very closely on any feedback we have, particularly from entities such as TAC. And at the same time, we have an opportunity to at least take the first step toward improving the original language that board council drafted with the LRC recommendations. And it makes me wonder whether we have to do the two-step of let's at least proceed with the stuff that came out of the LRC, because I think everybody agrees that that is a significant narrowing of the original draft language. And then we may need to take a little bit more time to then work with the board and councils on figuring out if there is an amendment language that we can agree to, because it sounds like it's not going to be that straightforward in terms of how we do this. If to go further than the LRC recommended pieces is not going to be that simple based on this discussion.
And I think that makes sense. And I think that to the extent that we've overscoped, that's why we need to keep in the language about as further defined by the board and rule. Jason Robinson, emphatic nodding.
I agree, Haley. That I think we go forward with what LRC proposed because we can always add in further defining with third-party equity or, yeah, and then also that other piece where, in accordance with the AICPA's code of professional conduct, we can add that because if we cross out the as further defined by the board, it negates that piece, and we can pull that piece into rule if necessary.
Yeah, I'm worried about the AICPA code of conduct. We just
I
don't
know,
what
me
it
too.
did. So
Yeah.
But so I agree. I think that keeping that piece, those pieces in there gives us more flexibility. I'm also not sure that we can not have the as further defined by board rule in there because I don't want us to look like we're I don't know, applying or allowing another organization to make our rules for us or our laws for us. Marcus.
If I can just briefly comment on section 2 there. The reason we felt strongly about this is that there was a concern that as currently written statutorily, that this could capture simple contract work between, say, a CPA firm and its business organization with a private security firm, a private internet or tech firm, because of the reference to services, facilities, infrastructure between a business organization and a CPA firm for a fee. That broadly, that could get into basic contract work between a firm and an outside entity. And so I think what this language was trying to add into this equation is intent, meaning the organization you're seeking to capture had an intent to form an alternative practice structure with outside investment rather than simply a business contract.
Yeah, but Ray, go ahead. Thanks, Marcus. Ray.
And again, I would tell you, I'm speaking for myself and not the LRC, but Marcus, when I see the reference to the AICPA code and its definitions of alternative practice structure, I think there's clearly a willingness on my part of myself and my colleagues on the LRC to try and work with you and trying to figure out what we want to pull from the code. That's a moving target at the moment. I think we have an exposure draft that has a different definition of APS than what's in the current definition of APS. And I think the board has a concern about trying to reach into the code and automatically accept whatever changes may come down the road. But I think there's also an attempt to try and get it right here. And I don't think that there's an attempt to regulate further than we were regulating before alternative practice structures and some of the challenges that they're giving us and other boards. So there's clearly, I think on the part of myself, and I'm speaking for a number of members of the LRC, we want to get it right. It's just, it may take another iteration working with you here to try and get to that point.
Amanda has her hand up.
Oh, yep, she does. Amanda.
Thank you. Yeah, I mean, and if the concern is bringing in other third-party service providers like, private security and those types of things, they wouldn't also have an agreement to provide professional accountancy services. So they're automatically excluded. Like it would never apply to them unless they're also, accountants that also provide private security, which is probably pretty rare.
That's true.
That's right, because you have the item A up there, yeah.
Yeah. Yeah, we have the and.
And it's an and, not an or.
Correct.
And I think somehow that got missed in that discussion.
Mhm.
So in the saving time, because I have to hop off here in a minute, can I make a motion to put forward the LRC's initial proposal?
Well, I don't know if we even need a motion. I think that we already accepted that. And at this time,
Okay.
we're not making any additional, I don't think we have consensus to make additional changes at this point. Is that right?
I would agree with that.
Yes. I see nodding from most board members. All
Okay.
board members.
So just to be clear and on the record, for right now, I feel like based on the prior motion, I'm directed to get the initial LRC recommended changes that were tentatively accepted by the board, that I have clearance to get at least those into drafting by
Yes.
Ledge Council. None of that prevents us from keeping the communication lines open
Yes.
with TAC on crafting what may have to become ultimately amendment language, if we can figure out further opportunities to clarify based on those concerns around third parties and the language here under item 2, which anyway.
Yes.
Yes.
Yep, that's right. I think I would feel better or less concerned about the AICPA code of conduct if we knew what Peak was going to do next. There's an element of like, are we in alignment or are we not in alignment with that piece? So we may hopeful that something comes out from there soonish.
I want to say that I'm in agreement with Ray's comment about the fact that is not finalized and it's a moving target. So I'm concerned about putting anything in statute specifically. If it was in rule, I wouldn't be as concerned because it's easier for us to change it.
Agreed. Yeah. So Martin, I think your assessment is, thank you, Tanya, that good comment. I think your conclusion for the record is accurate.
Thank you. Okay.
Anything else? Thank you all for your time on quick, short notice. Appreciate that. Our next regular board meeting is on Thursday, September 24th, 2026 at 8:30 a.m. And with the way things are moving, if we need to call a special meeting, we certainly will attempt to do that. So I adjourn this special meeting of the board. Thank you all. The time is now 1:00 p.m. Staff, please stop the